Welcome to this week's edition of It is Chaile Time. Okay, I had a very interesting experience last week. I attended to an arbitration. It was set down for a period of 3 days. And this is one of those cases whereby I actually felt sorry for the employee. I was representing an employer. I felt sorry for the employee because he was not represented. And I just felt at the time, and I still feel that way, that his case could have been much stronger if he was represented. So what are we talking about today? We are talking today about how important it is for employees to be represented at legal proceedings, at the CCMA or at the bargaining council, and obviously at the labor courts and so forth. Now, employees often feel, like in this case, that they can't afford legal representation. And granted, it can be very costly. I mean, to give you an idea, some law firms, lawyers, they charge easily 2,000 Rand an hour, depending on where you go. If you go to a top 5 law firm, they may even charge you up to 6,000 Rand an hour. Legal fees from a labor court application perspective can easily be anything from 150 to 200,000 Rand, give or take, depending on the case. So yes, it is extremely expensive to get legal assistance when you are faced with a dispute at the CCMA or at the labor courts. However, there are options available to help you. And here, just coming off mind, I'm doing some advertising and marketing here, okay? Trade unions like Solidarity, for instance, in your professional capacity, you can join Solidarity. You can even join organizations like Clientele Legal, for instance, who all provide you legal assistance whenever you need it. And no, they didn't ask me to put this up there. I'm just speaking it today because I can see the effect of employees not being represented at CCMA proceedings. Now, yes, you're going to pay your 100 Rand or your 200 Rand if you go to Clientele Legal or Solidarity or whatever the case may be. But here's the thing. You as an employee often don't feel the need to pay that kind of insurance, if I can call it that 100 Rand a month or that 200 Rand a month. But the day comes that maybe you get retrenched or get dismissed, or there's unfair labor, you're subjected to an unfair labor practice, or whatever the legal case may be, and then you need assistance. And you know what? Then you phone people like us. Can't we do it pro bono? No, people's not going to do it pro bono. Mostly they won't do it pro bono, okay? You're going to pay the 20, 30, 40, 50,000 Rand, okay? Because that's what legal fees cost. So you must think about this carefully. A couple of years ago, I worked for a law firm and we had a deal there. We actually called it Workers 911. So for 91 Rand a month, you can get full legal cover and representation at the CCMA and so forth. You know what? We've marketed extensively. Nobody was interested. Employees don't see the need for legal insurance until the day something happens, and then it becomes expensive. And this employee, in this case I was busy with, he also cried foul and saying, but he can't afford legal representation, so on and so forth. But he was quite a senior manager in the company. I'm sure he could have afforded that 200 Rand to be part of Clientele Legal, Because at the time when you need it, at least there are legal assistance. And these people can at least guide you on legal processes and how to interpret and apply the law, you see. Which is something that not all of us are accustomed to or trained in how to do. But okay, anyway, so let me start with a story of what happened here. It's actually legally a very complex kind of case, okay? Because this is the interplay between incapacity and misconduct. There are various legal principles that apply, and this employee just made mistake after mistake after mistake. And what made me feel so sorry for this employee is that I can actually, in my legal opinion, see that he is probably incapacitated. Now, I'm not a medical doctor, so I can't really medically say, this person is medically incapacitated. But from a legal perspective, I can safely argue that there are good grounds that this may indeed be the case. And later, it was medically shown indeed to be the case. Okay, so what happened here? This employee, at the end of last year, he had a stroke. Okay. And he's been booked off numerous times by medical practitioners. went for x-rays, was hospitalized. Long story short, he eventually came back to work, and at some point he misconducted himself. Gross insubordination and gross insolence and gross negligence charges was brought against him into a disciplinary hearing, and he appeared before a chairperson for a misconduct process. But okay, so as they went through the misconduct process, at some point the employee pulled out his file with all his medical notes, showing the x-rays. Now you can see on the x-ray, for instance, the condition of his brain. Now, I'm not a medical practitioner, but I'm not blind. I can see the brain was nice white. Apparently it's supposed to be that way before he had the stroke, and after the stroke it was black. Legal, for me, I'm not a medical practitioner, but it tells me there's something wrong there, okay? But anyway, the medical reports at the time stated that he is suffering from anxiety, he's suffering from depression. But there's nothing in the reports that say, hey, he's unfit to work, or he's incapacitated, he cannot work, or he cannot fulfill his role. Now, remember this. A lot of employees try to hide behind their depression to protect them against being responsible for their jobs, to protect them against being taken to task for charges relating to misconduct. But you see, the thing is, many South Africans are working every day with some kind of mental or medical impairments, you know. So just the fact that you have depression does not mean you're not fit to work. Okay, but there are a certain and a specific kind of depression, for instance, or mental illnesses that can actually impact your work. And typically we're talking here about mental conditions that impairs your cognitive and cognitive abilities. With other words, your ability to perceive data through your senses, your eyes, your ears, your nose, mouth, your body, and so forth, and then your ability to respond to those senses in a normal human way. That some people, their cognitive and cognitive abilities are impaired to the extent whereby they cannot be held responsible for their actions. Okay, that's why you will sometimes see in criminal trials that people want to send you for tests to make an assessment as to your medical capacity or your mental capacities, to see whether, you know, you can be held responsible, you know. So there are some instances whereby the reason for your alleged misconduct then is related to your incapacity or your disability, and you cannot therefore be held responsible. Now, the Labour Relations Act actually specifically provides for procedures dealing with mental or with incapacity, and it's always my interpretation that those kind of procedures are not drafted with the intention to dismiss somebody. It's trying to find alternatives, or try to see if you can amend the T's and the C's of the contract of employment. Because often, you know, when you look at incapacity, it does not necessarily mean that you can't work at all. You may just not be able to work in your specific role. So if you are a truck driver, as an example, you may not be able to drive a truck because maybe your leg got amputated, you see. But that doesn't mean you cannot be a receptionist. So the whole incapacity process, in terms of my interpretation, is geared towards trying to find alternatives. Of course, ultimately, if after a bona fide process it was found that there's no legitimate alternatives, sure, in certain circumstances it does provide for dismissal processes, okay? But now this employee had been charged for misconduct, and he submits these reports, but there's nothing in these reports that actually states he's incapacitated or that he's unfit to work. But the chairperson anyway then said, listen, hold on, let's just park this. You are now obviously making a case to incapacity. Let's venture into incapacity, okay? So he adjourned the misconduct process and said, listen, okay, I'm giving both parties, let's say, 7 days. You as the employee, he wrote him a letter and said, listen, answer the following questions. Number 1, do you actually believe you're incapacitated? Yes or no? Number 2, do you actually need time off, more time off? Yes or no? Number 3, are there any alternative employment here that you can see or that you would like to have? Keeping in mind at that stage, the employer, without having a medical report, already put him on light duty. So where he was now an area manager having to drive around a lot between sites, they made him head office based, so he was doing his work from head office, managing his regions from head office without having to drive around anymore. So the employer already assisted him. So the employer will also consider alternatives, but was it actually his view that he would like to consider an alternative? And then obviously, can you find an occupational therapist report, or an OT report as they call it, that actually recommends or states that you are unfit to work and incapacitated, yes or no? So he gave the employer and the employer opportunity to make submissions, and they gave the employee 7 days to make his submissions and to find out the report, whatever the case may be. The employer sort of made a mistake here, in my opinion, in that immediately the employee was hospitalized, so he couldn't really adhere to the 7-day timeline. And the OT report only came out. The occupational therapist did send an email to say, look, they can't give a report now, but it will be forthcoming after he's been hospitalized. The employer pushed this process, and while he was still hospitalized, continued to dismiss him for misconduct. Okay? So obviously there was no OT report that came out. At that time, the report eventually did come out like a month or so later, which actually then found him to be incapacitated. But okay, so in front of or before the company and the chairperson at that stage, he actually never stated that he's incapacitated. He never said that he's open or amenable to alternative employment. Not at all. Okay? He never made an argument that he needs more time off, whatever the case may be. He never submitted the OT report within that window. Okay? So these are the legalities that now face us at arbitration. Now remember, just quickly, he walked into arbitration unrepresented. Arbitration on itself took 3 days. Some benefits of getting legal representation. And this could have been somebody from clientele legal or solidarity or whatever the case may be. Number one is they've got expertise in the field of labor law. Legal representatives have specialized knowledge and experience, increasing the chances of a favorable outcome. There's objectivity. The representatives can provide an objective perspective, reducing emotional decision making, and obviously negotiating skills. A legal representative, they know what legal buttons to push, if you want to call it that way, and therefore they can better negotiate for maybe a settlement on your behalf. I just want to find something here quickly. Waar is daai? Kom ons kyk gou so. Sorry, I'm just looking for something here. There you go. Okay, so that's the benefits of having a legal representative. Now, this employee, first of all, let's just talk about some of the legal mistakes he made, okay? He did not have any understanding between the difference of an incapacity process and the misconduct process. In terms of the Code of Good Practice, Schedule 8 of the Labor Relations Act, he had no understanding, okay? A misconduct process is when you commit misconduct in the workplace. There's typically a disciplinary hearing which may result on a dismissal as a result of that or outcome of this disciplinary process. It's normally a fairly quicker process, whereby incapacity is a bit more of an investigation in terms of your disability or your medical status condition, and then also trying to find alternatives or amendments to your terms and conditions of employment, also maybe considering giving you time off. So a bit more lengthy process, and the process really is there to assist you to find suitable employment within the company. That is the case, that's before the parties. So that's the one thing. He didn't understand the legal process, but also he didn't know how to interpret his own situation from a legal perspective. Now this is important because during arbitration, he brought a note, one-page document from the medical practitioner, basically trying to interpret law by saying that somebody who's incapacitated cannot be disciplined, okay? Now, this is obviously, that's not the way to go. And I explained to him, listen, if you want a medical opinion, go to the doctor. But you don't go to the doctor for a legal opinion, okay? You go to your lawyer, okay? Because it is not necessarily true that you cannot discipline an incapacitated person. First of all, in this case, the medical practitioner failed to tell him that he is actually not incapacitated. It was not even her finding at the time that he is incapacitated. So why will she give a legal opinion piece on incapacity if it's not really relevant to him, you see? And also, it is not to say that all people struggling with mental illness, for instance, cannot be disciplined, okay? So there may be some truth under certain circumstances to what she is saying, but it's not necessary, and it wasn't applicable in this case, okay? So then the basic processes of arbitration. Yes, this guy made so many mistakes. Number one, bundle of documents. He didn't know he must make bundles for all the parties, okay? So we probably spent a few hours where the commissioner helped, and we all helped him getting his documents sorted out to make bundles. Then he didn't know he must paginate the documents for ease of reference sake. You paginate each page. We spent hours helping him sorting out his bundle of documents, okay? He did not understand, once we got going, the legal principles that applies to the different steps inside the arbitration process. Like, for instance, in cross-examination, you typically ask questions to the opposing party's witnesses, okay? He was trying to lead his case and tell his story over and over and over. I'm not exaggerating. That commissioner probably shouted at him 50 times. We probably spent a whole full day in totality just trying to get him to understand what cross-examination was about. It was a painful experience, okay? And then also lastly, there are eventually when I questioned him, he agreed to my version on many instances, probably to the extent where I shouldn't have. And it's not because he shouldn't be honest or whatever. It's just because he doesn't understand himself. My view, and once again, I'm not a medical practitioner, but as I listened to him for 3 days, it was silently inside me, my opinion, this guy is actually incapacitated. Because his ability to reason, it's just all over the place. I could see there's something wrong with this guy. I mean, he can't put sentences together in a constructive way. He can't stay on topic. He can't listen and remember to what the commissioner is telling him. And then, there's basic mistakes that he actually made. He needed some legal guidance. Like, for instance, when he was subjected to the discipline hearing, he was actually medically booked off. He, out of his own, came to the CEO and asked him if he can come back, and they had an agreement for him to come back on light duty. That's probably a mistake. He shouldn't have done that, okay? Also, while he was subjected to this misconduct process, he went to seek for job opportunities at a competitor. And they phoned him to do a reference check. They phoned the company. So now it came out, but listen, you are stating a case of incapacity, but you're looking for another job. Clearly, it's not your view that you are incapacitated. You're stating a case of incapacity, but you actually never say you are incapacitated. He got the OT report eventually, like a week after he was dismissed. There was still an appeal process, and he still filed an appeal. He received the OT report while the appeal was still ongoing. He never thought of submitting the OT report. A legal representative will have told you, submit the report. Now, this case has been dragging out for months, and he still didn't submit the OT report. And the commissioner's like, that you at any stage submit the OT report. No, Mr. Commissioner, never. What do you want the commissioner to do now? And things he said during arbitration. He then, when I put pressure on him for applying for a job at another company, he agreed to all of this and saying, because he's now going to get fired and that's why he needs a job and whatever the case may be. So from a pure legal perspective, he needed guidance on what to say and how to say things. But even before the time, the medical doctor is just there to assess you medically and try to diagnose you and try to assist you, okay? But legally, how do you conduct yourself in a relationship to your employer at that time? He needed legal assistance, So that is what today is about. Don't think you can always just go into it solo. And yes, obviously, this is true for employers also. But you see, the thing is, employers normally have HR managers and IR managers, or they have lawyers on their book that actually they consult with on a regular basis how to deal with matters, But employees are often not. They're left in the cold. And you know what? It's your fault. It really is, because there's assistance available that's very affordable, but we don't need it. No. But the day when you are dismissed, now suddenly we must do it pro bono. Nee man, jy gaan betaal. Gaan nie pro bono doen nie. Dit gaan duur wees, dit gaan baie geld wees. Verstaan? So you must think about these things now. You don't necessarily know what you are doing. The law can be complex. Now I understand the CCMA is for free. Okay, and they try to make the CCMA easy, accessible to deal with disputes speedily. But it's still a legal system. There are still laws that apply, and believe me, it is still complicated. It is not you just walk in there and everybody just do the way, or it's going to play out the way you think it will be. So you need assistance. That's the lesson for today, the importance of getting legal assistance, So if you can afford it, I understand we all can't afford it, really consider services like joining a union or join clientele legal. Maybe the legal help is there, and it can really assist you. Anyway, that's all from my side for It's Chaile Time this week, and see you next week.